Hello and welcome to another episode of the Tax Hour podcast. Today I'm delighted to be joined by Holly Threlfall, who is a partner and head of corporate and commercial at Wilson Browne. I wanted to get that bit right.
You did get that bit right.
And part-time baker, just to point out. Brilliant brownies brought in every time Holly comes. So,
Thank you.
Thank you. Right, today we're going to talk M&A.
Yeah.
Deals, maybe not quite just M&A. We'll probably go off piece at it, won't we? But I think the main thing that we've dealt with a lot is problems.
Yeah.
So how do we deal with problems? How do we deal with them during a deal? How do we structure companies? All of that stuff. So where shall we start? A deal team.
Okay.
If someone comes along to you and says, I want to sell.
Okay.
What do you say? What's the first things you're saying to them?
So the first things really is finding out where they're actually at, what their motives are, what their actual end game is, why they want to sell, what they're looking to exit, are they looking to move on, are they looking to retire? Yep. Then it's really thinking about what support they're going to need through that sales process. And it's not just about legal support. It's actually, have you spoken to your accountants? Have you spoken to your tax advisors, planned out your tax position, know where you stand, because you're going to have to fund quite hefty tax due on completion. And then have you spoken with any corporate finance? Have you spoken with anyone that can actually help you structure your business and take it to market? Yeah. It's so much more involved than people think. It's not like a sort of standard process. You don't have implied terms, conditions. Actually, selling starts 2 to 3 years before you get your heads of terms.
And how many people actually approach you 2 to 3 years before they want to sell?
That's probably one of the most frustrating parts for me, actually, as a lawyer, because what often happens is people come to us with the heads of terms, which is great, more than happy to help and step in and pick it up from there. But by that point, it's too late for us to get involved in any structuring or planning. And certainly for you from a tax side of things as well. If you're going to sell, the sooner you get your team of advisors in place, the sooner we can start to troubleshoot, start to help you mould the business both from a commercial perspective, working with your corporate finance advisors and accountants, working with your tax advisors, working with your financial advisors as well, thinking about your future, particularly on a retirement. You know, how much money are you going to have left? What are you getting out of the deal to enable you to retire into the sunset? And then the sooner we can work with you really on the legal side as well and get it all lined up.
So who's the first person someone should really talk to when they're thinking about selling? Is it you? Is it me as a tax advisor? Is it an accountant or corporate finance?
I think it's a team. Right. I don't think there's any one person, because we'll weigh in from a legal perspective. And we do often get involved in an element of project managing, depending upon the client and who else they've got involved or not got involved. If they don't have a corporate finance advisor involved, we probably have to step up a bit more on the project management side. If they have got someone there, then that can help, and they can really help pull everything together. But we have to coordinate so many different elements, and ultimately, the legal documents that you end up with have to pull all those elements together. So we have to work with your tax advisors, because actually, the drafting of something can make a big difference from a tax perspective and what your outcome is. So we have to make sure that you're happy with the documents and that it works from a tax perspective. We have to make sure that the deal terms we've got down, that we've documented, reflects the deals that your corporate finance advisor has actually brokered. And there's a lot of idiosyncrasies, a lot of bespoke drafting involved. It's very rare you actually get a straightforward, this is your fixed purchase price, we're done, that's it, all paid on completion, especially these days. So that makes it more complicated. Yeah. We have to work with your financial advisors, making sure that the payment terms, when you're going to get paid what, works out for you. So the legal documents have to pull everything together. So we have to work with everyone as soon as possible.
Yeah, and I actually think the financial advisor is probably the one that's maybe forgotten the most, because when someone comes, they say, okay, well, how do we structure this? Have we got the right structure in place? You know, everybody knows they need a lawyer. But sometimes it gets forgotten that a lot of, and I'm sure I've sort of talked about this before, but a lot of people who we're working with, especially if we're working with owner managers, they haven't done big deals. No. You might have entrepreneurs who do lots of sort of buying and selling. That's sort of, I guess, one area. But there's lots of clients who come and they've run this business for 30 years. They've never had a huge pot of cash because their wealth is in the business. Yep. And then it's all about, okay, well, what's your retirement plan? How much do you need to retire on? Yeah. But also, who's going to manage that for you when you've retired, because you've not ever sat on that level of cash wealth or whatever it might be. So I think for me, the financial advisory part is possibly if anything's an afterthought, it's that.
I would agree. It shouldn't be an afterthought,
Yeah.
but I think you sort of get to completion. It's like, well, what are you going to do with your money? Oh, I don't know yet. Okay, well, yeah, you need to speak with someone.
I think the problem is when you, and you always get different people because, you might have someone approach you, but they've already got an accountant who's good with tax, so, they use them. Maybe they've already spoken to a corporate finance and they've involved you. So you don't often, I think, end up with, even though you need probably 4-5 teams involved, you don't often end up with the same 4 or 5 teams very consistently. And when it's kind of, if people are operating in their silos, I've dealt with the tax side of this, you've dealt with the legal side of this, and the corporate finance person's happy with sort of how the deal is made up and structured and things like that. There's no one person stepping back, which I know you've already referred to it, kind of the project management. Someone has to take that role. Yeah. Because otherwise everyone is just operating in silos, and it doesn't really, a deal is sort of something that needs to keep momentum and all of these things. And if there's just one person sort of operating, I've done the tax, that's it, and nobody's really said, okay, when's this deal going to complete and all of that stuff. And I think possibly maybe it's the project manager's role, whoever takes that role should be talking about things like the next step.
It's always looking ahead. It's always being proactive. It's always about the next step. It's always chasing and following through, which we will naturally do. It's not just about keeping the momentum going on the deal, though. I find that if the client is taking that role themselves, they don't know what they don't know. I often have clients come to me, especially in the SME market, that say, I'm sorry, I don't understand the terms. I've never done this before. I'm like, well, that's absolutely fine, because this is what I do. This is what we've been doing for 10, 12 years. If you know how to do this, I wouldn't have a job. So that's not a problem at all. But if it's a case of I'm advising the client one thing and then they take that piecemeal and then they go and speak to their tax advisor and come back to me piecemeal, it can slow things down. But also things can sometimes get lost in translation, and we want to make sure that everyone is on the same page. So I actually find that having an all teams call or a meeting really early on to sit, even at the outset when you're scoping work and quoting, actually, let's have a call. I've got no issue having an initial call with people, with other advisors, and let's just sit and talk talk through the plan, talk out the issues, talk out really what the commercial goals and ambitions are to make sure that they're actually going to be reached by what we want to do. It's surprising, actually, the number of times a client's come to me with one thing and a particular problem, and we've gone, actually, that doesn't solve your problem. You've mentioned about this particular risk that you're concerned about, and what you want to do won't take that risk away. We can look at it from this perspective, but then there may be different tax implications. So it's actually coming to the table, having a discussion, and having open communication is one of the most key things, I think, in getting not only a good deal flow, but also making sure that you are getting the right advice and that everyone's on the same page.
I think, to be fair, that's a few times you've come to me mid-deal and said, we've got this problem. And they may be already using their accountant, but I think employment related securities is a very common one, for example. And an accountant is, I think, crucial on the deal, even if they're not sort of front and center. When warranties come in and the client's going, well, am I okay signing this off all these warranties and what needs to be disclosed? The accountant knows the history of the client more than anybody. So they're crucial. But then a lot of accountants, if they're not specialist in sort of certain areas, it's the not knowing what you don't know kind of thing. And so you've got a set of warranties, and then there's employment related securities. You go, no, you have got, because you can spot these things, even though you're not a tax person. You're like, no, I still know there's a problem. And then so there's been quite a few that we've talked either informally or more formally and engage the client as, what do you think? How do you think we should play it, kind of thing. So, I think how many people have we just had on the deal team now? We've got corporate finance, tax, legals,
independent
accountant, IFA. So that's five. And that's not 5 people, that's 5 teams.
That's 5 teams. Because there is a team behind everyone. And actually, I think it's a bigger risk, and I see more problems coming out of deals where you have got someone that's working with a one-man band or a smaller firm or smaller individual, and then they go on holiday for 2 weeks and the whole thing stalls because they're away. And we actually had this on a deal recently where we're acting on sell side, and the solicitor on the other side just didn't respond for a few weeks.
I think we had one where the I think it was the solicitor they weren't really expert in this area, and then they realised very quickly that they were out of their depth, and just everything was slow to come back, just because. And again, it's about finding the right team, and you do. I think when you're doing a lot of these things, you do work with the same people quite regularly. There might not be the same solicitor every time, but it's 3 or 4 solicitors quite commonly that you kind of have worked with quite a lot. And so, again, it depends where the client starts, I think, as to how the team gets built around that. Yeah. So you might have a corporate finance team who say, well, we work with these guys a lot, and they introduce those solicitors. But a lot of clients, I don't think, have a corporate lawyer necessarily that they've used historically. And so it might be the first time you've ever actually met this client. And so, I don't know where you feel work comes from in that sense. I think we generally, not just on mergers and acquisitions, but generally a lot of our work comes from accountants and tax advisors, for example. So I guess that's where a lot of this starts for us.
Likewise. A lot of it comes from accountants and tax advisors. A lot of the time a client will get them involved before us, largely because their accountant does their returns every year. Particularly if they're audited, they have an ongoing relationship with their accountant, and they seem to think that lawyers are just there for the problems, the troubleshooting. Oh dear, this has happened. And more reactive. We actually try and be as proactive as we can with our clients, have touch-ins. If we know what their goals and ambitions are, we will have regular touch points, try and reach out to them, stay in touch. And like I said, it's better to be involved sooner, and then we can help clients plan. If they come to us at the point of we've got heads of terms, let's go. Like I've said before, more than happy to help. But it does put us on the back foot with any issues. And I do always say, really, buying and selling businesses, particularly on the sales side, it's like a game of chess. You laugh because you know it's true.
Yes, exactly.
It's literally, you're like, okay, well, there is this problem over here that needs sorting. What's going to happen is we're going to do this to sort it. We're going to disclose it. They're then going to want an indemnity, or there's a tax consequence. You're going to have to pay for the tax or bear that. It's going to come out in a tax covenant. We'll be talking through with the accountants, talking with you with yourselves on what the issues are, working out what the outcome's going to be, and going to the other side with the best solution, and putting a proposition forward that would work. If we're aware of the issue before we even get to heads of terms, before we even have a buyer lined up, we can generally resolve the issue, and then you're just going to a buyer with, there was this thing, but it's all sorted. And then you don't have indemnities, you don't have warranties. It makes it much easier.
So there's 2 things you said there, and I'm like, which one should we actually focus on first? Getting it right, so sort of pre-sale audits or whatever you want to call it, or I feel like maybe it's worth us just breaking down what's actually involved in a deal. So we've talked about the deal team, and that you might want, the role of a corporate finance person a lot of the time is finding the buyer, but also structuring the deal. They're involved throughout. The role of the tax advisor might be structuring things correctly beforehand, identifying any tax issues, explaining what the tax consequences of the deal as it's been designed and can it be done more efficiently, all of those types of things. But what you were just talking about, we've talked about warranties, covenants, indemnities. How is a deal actually structured? So someone comes to you, there's no buyer on the table at the moment. Okay. What actually is the process, I guess, the typical process? And it's not always the same, is it? So I can't say what's the process.
There's no one process. And actually, this is part of the preparatory work we like to do with clients, is actually helping them understand what the process is going to be, and all those terms that you've just put out there that I've been mentioning. Because, your average seller, particularly SME market, like you said, that have been working on their business for 30, 40 years, if they haven't done any acquisitions, if they've only done organic growth, suddenly you come to the share purchase agreement and all of these complex documents, which are like 50, 60, 100 pages. It's like, I've got to read this 100-page document. I'm like, well, I'm going to guide you through it.
Yeah, I was going to say read and understand it.
Yeah, it's read it, understand it, and actually getting your head around that terminology sooner rather than later can really help. So preparing a business for sale, really the first thing I'd actually do is I'd look to raise due diligence on my client. Because I act on buy and sell side, we've got a buyer perspective on everything that we do. So I'd raise the same questionnaire in essence, because it's amazing how similar it actually is. There are obviously industry variations. If you've got a particular sector like childcare or a nursery or a care home, obviously you've got different regulations that need to apply. But overall, a lot of the base questions will always be the same. So we'll raise them with our clients. We will get their answers. We'll work through their answers, analysing it to assess what a buyer's perspective is likely to be. And then when we talk to our client about it, we don't just say to them, oh, this is what a buyer's issue will be. We talk to them about actually, this is how it's going to play out. This is what is going to go into the purchase agreement. This is what a warranty actually is. It's you giving a contractual promise. This is what the consequence of it not being correct is. This is what we think you're going to need to disclose. This is an issue that we can resolve beforehand, whether it's because, for example, we could have a situation where the business itself has got two different types of business within it. So you could have a company and it might have a B2B and a B2C, and they actually just want to dispose of one part. Well, actually, how do we do that? One solution would be, well, you just do an asset sale and just sell part of the business that way. But as you'll come on to, I'm sure that's not the only solution. And there may be plenty of other solutions which actually commercially are better overall, as well as from a tax perspective, enabling them to sell the main model. So that's quite common. If we come to the table with heads of terms, let's go, you can't do that planning. And
you can't do the tax either because heads of terms are signed. Well, a lot of the things you were hinting at just then in terms of you could do an asset sale, which is probably the least tax efficient in most cases, or you could do a demerger and split them off, or you could do a hive down and sell. All of these kind of better outcomes from a tax perspective. Once there's a buyer on the table and heads of terms are signed, you go to HMRC and say, we want to do this for the purposes of selling, which is a good commercial reason to do it, but you're preparing a company for sale, which is a natural stage of a company's life cycle. But if you're saying we want to do this for the purposes of selling, we've got a buyer on the table and it's going to save us, and you're not going to spell it out to HMRC, but they're going to know and they're going to ask the question. One of the questions will be, well, how much is this lot worth? Whether strictly that should affect their outcome is a different question. But if you say, okay, this is a £10 million sale, because you have to be forthcoming with HMRC, otherwise there's no value to the clearance in the first place.
Absolutely.
And HMRC are going to know. They can see your accounts, they can see your tax return. They know that if you're going to sell for, what figure did I just say? 10 million? 20 million? I don't know.
Yeah,
10 million.
Let's go 10 million. Yeah, we're selling for 10 million.
Easy in my head. So if you're going to sell for 10 million, but you've only got a base cost in the assets of 1, then you're going to have corporation tax on 9 million quid, 25%. Then you've got to get the money out and pay capital gains tax. Or do a demerger or a hive down and sale. And you can potentially sometimes get no tax, or if you're getting the money personally, you only pay capital gains tax, not corporation tax. All of these things. But HMRC is saying, yeah, but this is just all you're doing this restructure for, which you're asking us for clearance on, that you're not trying to avoid tax, is to save corporation tax. So we're not giving you clearance. So as it all comes back to, and you can say it time and time again, but there will always be clients who haven't listened to this podcast or haven't really engaged with that idea because. Especially as a business owner, you're too busy to be thinking about all these other things whilst you're thinking about all the problems in your existing business and generating sales or whatever you're busy doing. It's difficult sometimes, I think, to get clients to engage with that side until in their minds they are ready to retire. And by that point, they just want out.
They do. And it's an interesting one you're saying about working in the business, because one of the most difficult things, I think, for business owners pre-sale to get the best sale you can is to make yourself redundant. And it's a really tough concept to get your head around, because I'm not going to be needed. It's like, well, no, if you want to sell with a clean exit, with minimal earn-out or no earn-out at all, or a fixed deferred rather than a contingent-based deferred, for example, you need to make yourself redundant. The business needs to operate really well without you. So you need to take that step back. And when you're taking that step, why not use that time to look at the business and actually, is this the best package for sale, or is there a more attractive way to structure it for a buyer and find a prospective buyer, which is really what you're doing when you're looking at restructuring, when you're looking at demerging. It's not just about the tax. It's about actually, how do I make this business as efficient, as good as possible, and as attractive as possible to a buyer? And that's where your corporate finance team come in as well. Like, a good corporate finance team will help you not only with finding that buyer and valuation, but actually helping you structure your business from a commercial perspective. What works, what doesn't work. How do you need to restructure the team? How do you need to make yourself redundant? What do you need to do? What roles do you need to replace? What is a buyer going to be looking for? And that's really where they come in. Yeah,
and I think it's not just, if a lot of the time when someone first looks at a set of, or a business as a potential to buy, you're looking at historical data. So, having a corporate finance person early who can help you improve those numbers ready for sale is just as important as making sure your structure's in place right.
Yeah.
Oh, just had a frog in my throat for a second there. Okay, so going back to kind of the deal process.
Yeah.
Ideally, you've got a team in place early, and when you were talking about sort of the legals, I was thinking, I don't want to downplay the tax side, but I feel like there's a lot more to the legal side. So with tax, we're looking at the structure, and doing exactly what you do from a legal side. When we're on buy side, we have sort of a checklist that we will send and say we want the information about all these different areas of tax, and even if it's not applicable, then we send the whole thing, and it's up to the client to say it's not applicable. And so there's various areas of tax that we will be looking at sort of on a pre-sale audit. But actually on the legal side, you're not just looking at the corporate structure. You're not just looking at the deal itself. You're looking at sort of the employment law history and the regulatory history. And maybe I'm downplaying the tax because to me the tax is easier because I do it every day. But it feels like there's a lot more consequence to the legal side.
I think it's not just the consequence, but we, as you kind of alluded to earlier, talking about, we'll identify, for example, in the ERS and employment-related security.
Yeah.
We not only have to think about what's on our plate, but what other consequences are there that the client may not have thought about yet, or may not have spoken with the tax advisor about, may not have spoken to their accountant about yet, may not have thought about the bigger picture. And it's not just within the realms of corporate and commercial law, but other areas of law as well. So as a CoCo or corporate commercial lawyer, we sit quite central, but we have to know about other areas quite specifically, which I think a lot of people clients don't appreciate. So people say to me, what is corporate commercial? What do I actually do? And sometimes it's easier to say, actually, what I do, if it's not property and it's not employment and it's not commercial litigation, it probably sits on my desk. So it's a bit of a bizarre way to define it, but we deal with everything from helping businesses start up, their governance documents and their structures. We help them with funding and with loan agreements, not finding the funding, not giving them financial advice, but when they've got a loan agreement or a debenture or invoice factoring, we can go through the legal terms and make sure that they understand what they're signing. Personal guarantees in particular is a key one there. We work with IP registration, work with trademark protection, their contracts, their terms and conditions of trade, their GDPR policies, making sure all of that's aligned. Health and safety regulations. We do work with our commercial litigation team on that. There's a whole spectrum of laws that apply to a business that we have to know and think about. And then you get onto regulatory as well. So when it comes to pre-sale audit, typically we'll think in terms of different sections. So corporate structures is the first and most obvious one. So actually, what is your corporate structure? Now, most clients think, I've got a really straightforward structure. It's me and my wife, or me and my family, or me and my business partner. There's two people, 50-50, or a few people, 50-50. 30-30. Yeah, proportionate. You can have a few people.
Yeah.
But then sometimes you get actually, there's me, I'm 90%. And then there's John Smith, who's my employee I gave some shares to 5 years ago. Now that will automatically tick in my head.
How did you do that?
Exactly. On what terms did you give him shares? Did he hopefully buy the shares for market value? No. He's been with me for 50 years, so I wanted to award him. Okay. Did you have tax advice on that at the time? No, I just signed a stock transfer form. Okay. Let's get Nick involved.
Yeah, exactly. That has been a number of conversations.
Yeah, that happens. Let's get someone involved as soon as we can to talk through this issue. So sometimes when we get on the corporate structure, we're already fleshing out what could be a tax issue or a consequence that needs to be thought through. Sometimes it really is actually straightforward, and that's great. That's not a problem, and very much the report is, this is it. Yeah. Buyer's not likely to have any concerns here. Do you have your statutory books? Clients often don't know what they are, so we ask them to speak to their accountant and they send them over because they often maintain them these days. So that's the kind of the corporate structure side. We look at shareholders' agreements, we look at their articles, because they can have bespoke provisions that have specific procedural requirements before you can transfer shares. Yeah. So if you're going to sell to an arm's length buyer, that's got to be followed. So it's understanding actually what your structure is, what's in place, and are there any historic issues in terms of restructuring that have happened? Yeah, and I think a lot of everything you've just said there, and it's obviously the preferable thing for us is, can we do this a lot sooner than a buyer's even on been thought about, so that we can fix anything. But a buyer is, even obviously when we've gone through this with the fine tooth comb, a buyer is still going to be doing that themselves. They're going to do the exact same exercise. And as soon as something
is picked up, if this pre-sale audit hasn't been done, all of a sudden you thought you were going to sell for 10 million, the buyer says, well, we've identified this, whether it's a tax or legal, whatever problem it is, either at the very least, they probably want a warranty, but more likely they want a retention until it's sorted if you're trying to get a deal done, or they just don't want to do the deal until it's sorted.
I've seen so many issues, particularly with corporate structures. With corporate structures, you're more likely to get a warranty won't be enough. If you're a buyer, you won't want a warranty, because a warranty you can disclose against, and if a buyer buys in the knowledge, if you make proper disclosure, that protects the seller. That's the whole point of a disclosure exercise.
So sorry to interrupt you. So we've got an SPA, share purchase agreement. It's got lots and lots of clauses in. Obviously, one of the headline ones is what's the consideration? Is it paid up front? Is it deferred? What the terms of all of that type of thing. And then we have a load of warranties, covenants, indemnities. So the warranty specifically is, and this is probably the longest part of those three items. There's often a lot of warranties in there, even if they're not relevant. They still say, for instance, you've had a standalone company, and then you've got a whole load of warranties about a group that you still have to give. So what the seller is doing by giving these warranties is saying, if any of these things do come to light, like let's use our employee example. Give an employee shares, and the seller thinks it's all done right, so they give a warranty to say that there's no employment tax problems.
Okay.
If the buyer then acquires the business, having given that warranty that we're selling this company to you for £10 million, all of these things that we're giving you a warranty about are fine. The buyer then finds a problem. What happens then?
So if there hasn't been adequate disclosure, which I'll come on to, if there was a warranty given and it turned out to be untrue, the seller's potentially going to face a claim for breach of contract. That is not only going to then result in costs. If there was deferred consideration, there's likely going to be a set off provisions. They may not get all the consideration.
All the money,
they may well have paid all the tax on it at this point, but they won't get all the consideration. They're going to have to defend a claim for breach of contract. That can be very lengthy in terms of time. It can be an absolute drain, just even on emotions. Like, if anyone's been through litigation, they'll realise, don't worry, we have a fantastic litigation team. They're there if you need them, but we'd rather you didn't. It's, if you don't make full and proper disclosure, if you end up in breach of warranty, then you have got a problem, not just because of the monetary outlay that can cause, but actually the stress and the time that going through litigation and those proceedings will cause. Because at that point, you're trying to settle if you can. If you don't try and settle, you end up in court. If you can't reach terms, you end up in court. It's a very stressful process. So we are always saying to clients, you're best to disclose, you're best to be honest. So when you've got a warranty schedule, as a seller, you always have an opportunity to give disclosure. And that's not a conversation you had on the phone with the buyer 3 weeks ago. It's a formal letter that we help you with and formally notifies the buyer of, we know you've asked for this warranty, but there's this thing over here you need to be aware of. So the easiest example to give is actually litigation. We know you've asked for a warranty. There's no litigation pending against the company. However, we had this customer raise an issue last week and we don't know where it's going to go, and they're threatening us. It's completely unfounded. Here's the evidence as to why. Here was all the assurances. Here was the situation with the contract. This is what happened. It doesn't matter that it's unfounded or not. What matters is you've got this situation that you now need to deal with. Comes up more frequently in employment. For example, could be, we dismissed Joe Bloggs because he was stealing from the company. He's saying it's not because of that. It results in an actual dispute. The fact that it's there isn't always necessarily an issue for the buyer. It's how you're dealing with it. Have you taken legal advice on it? And what is the risk? What's the assessment of the situation? It's being transparent with your buyer. It's putting it in disclosure. It's putting it in the letter. It's responding to it in due diligence, being upfront and honest. Here's my solution. Here's what I'm dealing with it. Now, if it's considered to be low risk, and if you've made proper disclosure and you've got a solution in place, or you've already solved it, and it's just notifying them of a historic thing. For example, there'll be a warranty that there's been no 2P transfers in the last, normally it's 6 years or 10 years. And actually, you might have done an acquisition. You might have bought a business yourself 3 years ago and taken on 3 employees. So you disclose. There was a 2P transfer. We took these employers on. Here was the measures letter that was sent to the employees. This is what happened as an outcome.
So the disclosure letter can have plenty of completely absolutely fine things.
Absolutely.
It's just making the client, the buyer, aware that
absolutely. Most of the time, we have what we call non-contentious disclosures that we look at and go, it won't be an issue. It's standard. You dealt with it in a standard way. You did everything right. We just formally notify them because the warranty is drafted so broad. So we're just making them aware as they've asked us to do. So that's really what goes in the disclosure letter. If you have got something that needs to go in that is going to be contentious, for example, gifting John Smith shares in your £10 million company 5 years ago, then we need to disclose. We need to disclose ideally with a solution what we're doing. But that's where the buyer's going to go, actually, I do see this as an issue. And what they're going to want is an indemnity. Now, that is different to a warranty. A warranty is just your contractual assurance and its assumption, and you can disclose against it. So if something is properly scoped in your letter, the buyer can't claim against you because you say, well, actually, no, you were aware of that when you bought.
Yeah.
That's the whole point.
That's why you paid 10 million for this, because you knew it, and you could have reduced, anyway. You could have sort of raised the problem at the time, you didn't.
Yeah, exactly. And indemnity is where the buyer actually goes, do you know what, I know you've told me about it, but I'm not willing to pay X, or I am willing to pay X, but if this does become an issue, you've still got to be responsible for it.
Yeah.
And indemnities work on a pound-for-pound basis. Now, you have to bear in mind, when you enter into an SPA, particularly normally when you're in the SME market, it's normally the individual selling. It's very rare you'd have a holdco selling the trading subsidy. Normally you're selling as individuals. So for all your 30 years trading a limited company where you've not been on the hook unless you've, health and safety law or breached your director's duties, if you've not wrongfully traded and you've generally operated well, it's limited liability.
Yeah.
Suddenly it's not. And it's actually coming out of your pocket. You're on the hook for this SPA. You're on the hook for the warranties you're giving and the indemnities that the buyer wants.
Yeah.
Now, the sooner we're aware of an issue, the sooner we can navigate it. We can look to limit liability under indemnities. We can look at caps. We can look at time periods. There's things we can negotiate. But if the problem fundamentally isn't resolved at the point of completion, it's unlikely that you're going to proceed without an indemnity as a buyer, which is why I said a warranty wouldn't be enough. A buyer would probably want an indemnity.
And a retention. So when I say retention,
potentially,
£10 million, we think this could be a £500,000 problem. We're going to pay you £9.5 million now, and as soon as it's resolved, we'll give you the rest.
Yeah, seen retentions before, and the other big one's purchase price chips. I actually once was acting for a buyer, and the seller disclosed a couple of days before completion they hadn't paid a gas bill in 10 years. I genuinely, we looked at it, and I had to call my client, like, they've just disclosed this, we had to talk it through. And my client went away and said, actually, we calculated based on what we think they could potentially recover time-wise, because there are various statutory limitations as well. Right. But at the end of the day, my client's like, I'm not proceeding based on this purchase price. And, it was a case of reduction of the purchase price and an indemnity. It really can vary.
And I think that's what... The problem is, once you've signed heads of terms and you've said, okay, at heads of terms, you've not yet had anybody crawling all over your books, looking through all the legal history. So the sellers are already thinking, this is a £10 million deal. This is how much I'm going to get. They've probably already roughly worked out what the tax is going to be. So in their pocket after this, they're going to have, £4 million each if there's two of them. And then you go further down the line and there's this issue that's highlighted and they say, actually, we're only going to give you 9 million, not 10. And they're thinking, hang on a second, no, because I've already spent 4 million on this house I was going to buy or something.
Yeah.
And so coming back to that pre-sale audit type of activity, doing that will mean that you're in a much stronger negotiating position when those types of things arise, or you've already done.
Absolutely. And that's also going back to the first point about the team, because if you have got sudden adjustments in the purchase price, knowing what you're going to have net at the end of the day, when you've paid your tax, when you've paid everything due, when you've paid all your professional advisors, making sure that what you get as an outcome is enough to sustain with what you want to do next is really important. So getting that
where the financial advisor
comes in. Yeah. But we mentioned about obviously the scope of legal, and we got sidetracked from corporate structures. We have your contracts, your terms and conditions of trade, what's on your website, on what how did your website work, what are your terms and conditions with all your suppliers, what are your terms and conditions with your customers. Crucially, where are the variations from your standard terms and conditions? What customer have you agreed, I will give you 180 days because you've been with us for 10 years rather than 30 days? Where are those variations? Where do they sit? Are there any change of control provisions? And that's quite common, particularly in banking documents. Is this transaction going to forfeit a facility potentially? That could have a huge impact.
I've seen that also on customer contracts where maybe they've got an ongoing contract with a customer depending on what industry they're in, and then there's a change of control that says actually if these shareholders walk away, then they can stop that contract.
Yeah.
So if that's one of the main contracts, the main turnover that customer is responsible for, then the buyer unless they have assurances from that specific customer, the buyer might just say, this isn't worth 10 million to me now, is it?
No, absolutely not. And looking through the customer base, looking at what the revenue generated by customers is such a key part of particularly the financial due diligence as well. But if the legal contracts don't underpin that retention, then there's a problem. And actually, that's one of the reasons people look for a share sale over an asset sale, is because with an asset sale, there is normally a break of continuity. You have to assign contracts. Yeah. If there's a non-assignment clause in there, you've got a bigger problem. If there's a non-assignment clause in there, but there's no change of control clause, well, then the contract sits in place. It's then about maintaining relationships. So contractual scrutiny is a huge part of due diligence, particularly from a legal perspective, because it underpins it all. Yeah. As you mentioned, employment, understanding what the employment history is, what handbooks are there, but actually have they complied with the latest employment laws? Employment law is ever changing. It's really dynamic. And actually, even the way different things are assessed, like holiday pay, there was a huge shift in that a few years ago, and making sure that's been paid correctly is a huge thing. And actually, there's a lot of indemnities often asked around holiday pay as standard now, because so many people miscalculated it. Property. Where do you trade from? On what basis do you occupy this premises? And you'd be amazed actually the number of times either the freehold's actually in a pension fund, which is part of part of planning,
of people do tax
and that's not a problem. Or actually the property might be in the company and they want it in a pension fund. Once again, if you do that at the point of sale, it's going to be a nightmare. If you do it beforehand, you've got the time to plan that and do it all and actually move it out properly. It could be leased. What are the terms of the lease? Unlikely, but is there a change of control provisions in leases? There can be. But actually, what are the terms of the lease? Are you holding over under a lease that's expired? Does it have security of tenure or not? Is it a fully repairing lease and the property's in a dilapidated state? Buyer's going to have loads of issues there if there is. So actually understanding what the property is, the basis of trading from that property, it could be the buyer doesn't need it. They might want out.
Yeah, I was going to say, sometimes buyers actually don't want the properties.
No.
And that's, again, where we come in to split it out.
But if they've got 10 years left on the lease and they're tied in and there's no break clause, what are they going to do? Yeah. It's navigating that. So that's where working with the CF advisors comes in, because actually commercially, what won't or work, what is and isn't working, what are buyers looking for or not looking for, particularly in your industry, in your market, what is attractive about this and what is not attractive about it. And actually, if it's not attractive, how can we deal with it? Actually, if a buyer isn't likely to want the property for various reasons, then is there a way we can extract it? Is there a better use for that property for that individual as an overall income?
To be fair, if a client comes to us as one of the first ports of call, it can often be, this property is my pension fund, so I am going to want to sell the business, but I want to retain the property as a rental. And again, that's where we come in and say, most of the time, and it's not every time because it depends on all of the different factors, but a lot of the time you're talking six-figure tax savings by having dealt with that well in advance of a sale. I think the last one I calculated, they're not huge values. I mean, we're still talking about 10 million sort of deals. And I think the tax saving by demerging was about £800,000. And you just think, if you don't, for those who don't get the advice early enough, you're just losing these opportunities. Yeah. So I think that's really important. One thing that, as you were talking through all of these things, because there's hundreds of things, I feel like maybe we should talk a little bit about deal fatigue.
Okay.
So generally speaking, if you pace this and okay, this is to me a 2-year process, we're going to start talking to financial advisors and corporate finance and lawyers to get the company in a very good position ready to sell, that normally means things are going nice and steadily, the deal then happens and it goes quite smoothly and it's job done. If you don't do any of that planning, most of the time that's where I think the deal fatigue happens. And I think if you've got, as you said, if you've got someone who's basically retired out of the business already and made themselves redundant, that probably helps them during the deal process as well, because they're focused on it. But a lot of business owners who are continuing to drive the profits are trying to do all of those things that you've just mentioned whilst also trying to run the business, and probably saying we want to sell within a sort of 3 months seems to be the standard when you
even if 3 months.
Yeah.
Most say can we sell by the end of the month?
There is that, or by the end of the tax year when it's the 25th of March or something.
Something like that, yeah. Actually, I did have that this year. Someone wanted to do a deal by the end of the tax year. So,
and it was March, wasn't it?
it was, I think, like the Thursday before the end of the year. It was a different situation to normal. It was an acquisition from an administrator, so they do often happen very fast paced. But it was a case of, okay, if we want to do this, I'm going to be working over the weekend, so this is where it's going to play out.
And so that's deal fatigue, I think, happens very, very often, and the more issues that are identified during due diligence is where you end up talking to clients and they're just like, I just not thought this is worth it anymore.
It happens.
Yeah.
Deal fatigue, and particularly, like I said, if we haven't been involved in the prep process, so if clients aren't aware of what all of these things are, what disclosures are, what a disclosure letter is, that they're going to get a 60-page warranty schedule, that they're going to have a tax covenant, which is a whole different thing we haven't even talked about yet, that they're going to have a complex earn-out provision or completion accounts, and once again, I'm throwing terms out there that they won't necessarily have come across. If they haven't been prepared on what to expect, if they don't know what to expect and they think, okay, right, it's heads of terms, and the next thing is I'm going to get a contract to sign, and that's it. I mean, it's typical for an SPA. You have several terms of it. It can be 3 or 4. It can be 8 to 10.
Yeah.
Because there are points to negotiate. It is about balancing the two risk profiles, about balancing the buyer needs with the seller risk profile, and actually how it sits and what's fair, what's reasonable, what works for this company, these sellers, this particular transaction. It is very tailored, and that can be really where the deal fatigue kicks in. It can also be in due diligence because you're trying to run your business and you're trying to respond to all the inquiries, and then often the disclosure process often mirrors due diligence. In fact, if it doesn't mirror due diligence, I'm more concerned about disclosures because it means that there's things that haven't come out of the woodwork yet that are likely or could still rupture a deal. And the later on that comes out, the more annoyed a buyer is going to be, the more indemnities, the more costs, more retentions are going to come out of it. If it mirrors,
or they think this is so high risk, actually this just isn't worth the deal now because they keep coming up with things.
Or what else haven't they told me? What else? Oh no, it's everything. But how do I know that now? And a buyer doesn't want to be bringing a warranty claim either. They really don't, because they don't want the stress of having to go through it and recover if they can avoid it. That if the more upfront you are earlier, the better. So whilst the disclosure process can be frustrating because it can be very similar to the due diligence process, actually the more they mirror, the better, because it means they're already aware of it. And then actually what we're doing when we're disclosing is saying, you're already aware of this, I told you a month ago.
Yeah.
And you didn't raise an issue then, so why would you raise an issue now? So you kind of know what's going to happen then.
Yeah.
But it can be exhausting. I once had one client, and she owned a business that had 3 premises, and she was sole shareholder, director, and trying to respond to inquiries and run everything and manage this business. And hats off to her, she did an incredible job. Yeah. But it was really, I was getting late night emails where she was trying to scan in pages.
That's the problem. They're always late night things because they're working their normal hours in the day.
Yeah, exactly. And don't want staff to know. Don't want employees to know. Don't want staff to know. Certainly don't want customers to know, or anyone, that this thing may or may not happen. Particularly because in corporate transactions, exchange and completion is often simultaneous. It's very rarely split, which is mainly if you're waiting on a consent or regulatory. So if you're FCA regulated, for example, you may need to get consent, or it could be NSIA, or sometimes you might be waiting on an outcome from HMRC or something on whether or not this particular issue that we identified is going to be cleared or not. Yeah. So you may split it if you've got a third party you're waiting on, but most of the time you are literally working to the wire to get this over the line. And you get your report from us at like 6 o'clock the night before, and then it's okay, right, this is all agreed, let's get it signed up, let's get it completed. And it's done, and suddenly it's done. It's a bit of a strange one. So there can be fatigue. Ways to combat it other than take a break. Is there anyone you can trust in your business to help you with it? Are there multiple sellers? I've had it before where you've got 4 sellers, for example. They'll appoint one seller to take the lead on the transaction, and they step out of the business, and the others focus on the business. Obviously, you've just got to manage that with your staff. The other sort of thing is actually working with us as much as you can. Let us help you. I've sent trainees before. That's
why you're paying us, basically.
Yeah, you're paying us. But let us help you. I've sent trainees to help with due diligence, or we just say we're doing a legal audit, or I've just got a lawyer coming in. Or my accountant's in today, my tax advisor's in today. They don't necessarily have to see what you're doing in a room. The other thing to do is, from our perspective, we try and be as proactive as possible. This is what's going to happen next. This is where we're at. This is the next stage. This is what we think the issue will be. If we've had 2 or 3 turns of an SPA, get an issues list together. If you can narrow down, okay, actually, we're not talking about drafting points and whether it should be will or shall. I'm not interested in that from a commercial perspective. What are the actual commercial issues? Is the issue with the drafting going to have a commercial impact on my client? yes, we need to talk about it. Get an issues list together, get everyone on a call, have a roundtable discussion, let's talk it through. If we can get agreement on the commercial points, the legal can normally flow quite readily. And then it's a discussion between me and the counterparty on, okay, well, does this drafting work? Yes or no, and why? But just being open, this is why it's not working for me. This is what the issues are. This is what the concerns for my client are. This is how it can be construed. Can we add some clarity here? Or this is actually what their concern is with this particular element. It can be as simple as they've drafted restrictive covenants really broadly saying they can't have any contact with customers. One of the customers may have had for 30 years and they have them out for dinner every year for their birthday. Like, as long as it's not detracting from the business, yes, you can argue there's no commercial loss. Can't bring a claim without a loss. But actually, it's on my client's mind. They want to be clean. So actually, scoping out saying they can contact customers as long as it's not competing with the business, not looking to detract business or reduce the business. There's different ways you can approach it, but actually looking at it from the other party's perspective, talking to my client, actually you can understand why they don't want you to go and start up a competing business or do anything that's going to detract the customer from continue working with them. So it's about being honest and open. Yeah,
and I think for me, deal fatigue, the two biggest things. I just as you were talking, I was thinking of a client who I had who there were just issues coming up, and you talk to him and explain one thing. 3 weeks later, something then materialises in the third turn of the SPA or whatever it is, and he goes, "What on earth is this?" And because he's been concentrating on so many different things going on in the deal, like, no, we have spoken about this. And he's sort of gotten really stressed and thought this is, it's going to break the deal or something. And actually, no, we've got the resolution. We've spoken about the resolution. It's just that. So I think deal fatigue creates worry and things in the client's mind sometimes. And then on one of the same client, on one of the issues that was identified, which I was perfectly happy we could easily resolve, he was like, "I'm just going to give in. I just want this deal done now." So, they'll do the deal as long as I knock 200 grand off the purchase price. So let's just do it. And you think, had we dealt with this in an orderly fashion, that's not necessary. And that's not the only time I've seen stuff like that. So, deal fatigue is probably the one that I'm not sure I'd actually like that phrase, but it's a very real thing. It is a very real thing, and it's a really difficult thing. And hats off to vendors, because it is a really tough thing to run your business and try and sell your business at the same time, and do it all and feel like it's all on you. Yeah. I have likewise seen it where people have gone, I don't care anymore. I don't care anymore. I just want this thing done. Yeah, just get me out of this. And but from my perspective, I have to advise my client of the situation. I say, you don't have to do this. Have you spoken to Nick on the tax side? What are the wider implications of what you're agreeing to do? Yeah. Particularly with purchase price chips. Think about the wider implications, the consequences for you. What is the ripple effect of this particular decision? Yeah. It's not always about purchase price chips or money. Sometimes it can be the commerciality, the drafting. Often, a lot of the time in the negotiations fall onto the terminology for completion accounts and earnouts. Dealing with completion accounts, earnouts. What is normalised target working capital? What is normalised working capital? What is the target working capital? Yeah. There's always a lot of negotiation around that. And ironically, it's not actually the lawyers that negotiate that bit. No. We work with the accountants and the corporate finance mainly, on actually what is this? But understanding how different items are going to be treated, what's going in the completion accounts, what are specific policies, what is going to apply here. Because actually how that plays out can have a big impact on a client. So if they've got a specific policy saying that any debt over 60 days is going to be treated as a bad debt, and actually they're not going to realise the value, and that won't be acknowledged, and actually they've always had 90 days over 90 days as a bad debt, that's going to have a big impact on what they ultimately receive. So actually that's where a lot of happens. So you end up with deal fatigue because they end up a lot of time talking about the target working capital, normalised working capital, or particular definitions, particularly if you've got an earn-out that's profit-based rather than turnover-based. Profit can be easily manipulated sometimes. So defining what that means.
Defining what it means, what falls into it, and what a buyer can and can't do. Buyers want control. They've paid a lot of money. They've paid £10 million for this business. The seller may not receive that when they've paid everything out and when they've paid their tax, but the buyer's paid out £10 million. Yeah. So from their perspective, it's their business. They want control of it. Mm-hmm. Respect that. But if you've got an earn-out provision that's based on profit from a seller's perspective, if the buyer was to increase directors' salaries, it can naturally reduce the profit quite easily.
Yeah.
It can be so easy to manipulate. If the buyer decides to uproot the business, move it out of the premises, go and take a bigger premises, which has got high increased rent, they may be doing it for genuine commercial reasons, and they can see increased profitability in 5 to 10 years. But it's a 2-year earnout. It's going to be a problem. So the ripple effects, thinking about the ripple effects, thinking about what the consequences are, balancing the buyer's commerciality and their situation with what the vendor concerns are.
Yep.
You've spent a lot of time focusing on that, and then we come along with, and here's the purchase agreement, and here's your restrictive covenants, and here's this, and here's all the warranties, and let's go through the disclosure schedule.
Yeah.
And you've already been through due diligence, and it's like, what's next?
Yeah.
It feels like there's always something else. So I think having that preparation can really help negate that, because you already know what's next. It's like, okay, we've done this, I know that's to come. You kind of give up for it, but if you don't know, it can
it's just
be a bigger hit.
Yeah. So back to kind of a typical sales process. Hopefully we've had a pre-sale audit and we've ironed out any problems.
Yeah.
Then I guess before you even get to signing heads of terms, you go to market, however that might be. You might already have a management team, you're just selling to your management team. You might actually have corporate finance go and find people, because that's kind of the value of a corporate financier. And a lot of these deals is that they're the ones who actually bought this buyer in who you didn't know, you've never spoken to, you wouldn't have been able to find them, but corporate financiers have their ways. So you got the pre-sale audit, you then find the buyer, you then signs heads of terms, which is just, we're entering into this period where we're exclusively talking to each other, we're not trying to find anybody else. And broadly, this is the terms on which we're going to do this deal, subject to due diligence and all the rest of it. Then you go through this due diligence process, and the warranties and the SPAs are drafted. And then finally, then we've also got dealing with things like, as you say, the normalised working capital and all the rest of it. And then finally, we actually do the deal.
Yeah.
Hopefully, everybody's happy. Can't always be the way, but and so it's that in between period, I think, that's the biggest stress, I think, for most sellers. But even once you've done the deal, you normally then you've got a period for the accountants to prepare completion accounts. Yeah. And then I guess the work isn't then done, because that's when the IFAs really come in and say, okay, this is how you've now got all this cash in the bank. How are we going to structure it?
What are we going to do with it?
And sometimes that's when I come in for family investment companies and stuff like that as well. So there's a lot of it can be a long and drawn out process, but I think it's just about managing expectations at the end of the day.
I agree. It's expectations, and also, as you've just alluded to, post completion, it can be so easy to think, oh right, we've completed, that's it, the job's done. It's really not, particularly where you've got earnouts, particularly where, if you're staying in the business, even if you don't have an earnout but it's a fixed deferred, which has become more and more common. Yeah. And there's been very few deals, I'd say, in the recent years, it's just been an absolute 100% on completion fix. Buyers more risk averse, investors more risk averse, banks more risk averse. So you're finding more and more being deferred, even if it's a fixed deferred. It's in the seller's interest for that to be a success. Yeah. Because they want to get paid. So actually, that handover of the business to the buyer, how do you introduce the buyer to your staff who didn't know anything about it until a day ago, or didn't know about it because you didn't tell them, because simultaneous exchange completion, like, why would you tell them if it's not definitely going to go through? No one's legally obliged. So okay, you've sold this business. How do you introduce the buyer to your staff? How do you introduce them to your customers, your key suppliers? Actually, this thing has happened. That is going to be crucial to the success of the business from a buyer's perspective, as well as from a seller's perspective, because even if you got 100% on completion, it was still your business you've worked on for 30 years. You want to see it succeed.
Most people at least want the business to carry on well, or they at least care about their employees. They don't want their employees all made redundant.
Absolutely not. And they go, do you know what, I started that, and you want to be able to look forward in like 5 years' time. So that business that everyone knows of over here, I started that, and this is where it's gone to. This is what it's grown to. So that post-completion, immediately post-completion, then, as you said, earnouts and completion accounts. So completion accounts are normally where you've got a post-completion adjustment, either based on current assets, or where it could be based on fixed assets, but more often than not, it's current assets.
And this is because when you've done the deal, obviously on that day, you can't know the exact sort of sales up to the date that you've done the deal. So you need a little period for the accountant to actually be able to bring all of that together in a set of completion accounts, which probably isn't going to be your year end.
No. So it would normally bring it up to date. So you'd normally warrant, for example, the accounts and the last statutory filed accounts. You'd warrant the management accounts until completion. But what happens to the profits of the company between that time? So the buyer might make an offer based on those figures, but actually you've got to bring it up to date, particularly if the buyer wants to make sure there's X amount of working capital in the business. They're going to have to account for the cash, the stock, the WIP, the debtors. They will account for everything, the creditors, and then there's an adjustment following the completion accounts exercise. So that in itself is a lot of the negotiations, a whole schedule designed around actually what's the adjustment and when is that due, and fundamentally what happens if the parties can't agree, because you've already completed, you've already sold.
Yeah.
So at that point, it's how do you then deal with a disagreement? What if the buyer's assessment of the figures is different to the seller's assessment of the figures and what they want? So then we have to build in what we call expert provisions, where it will go to a third-party expert to determine who's the expert, what are the regulations around that. So this is why we get paid. This is what we charge for, is thinking through all of these what ifs. Our job is to think of all the worst case scenarios that we can, not because we're just looking to be negative, but because that's our job, is to look at them and explore them and look to protect you and make sure our client is informed. If they want to take a risk on something, that's absolutely fine. But my job is to make sure they're aware of what that risk is, to think through the ripple effects. Then they can make an informed decision on whether to proceed or not to proceed.
And I think that's where it links together, because you'll identify these things, but you might say, okay, but we need how does that affect the tax position?
Absolutely.
That's going to affect their net cash position. And
I think with tax, particularly in the pre-element, we're talking about, preparing for sale. A lot of people don't think about all the different layers of tax. This is really where you come in, because there might be the obvious ones that they think of are like corporation tax, but actually, if you're looking at demergers, we're thinking about, okay, well, where do you sit on corporation tax? Where do you sit on gains? Where do you sit on stamp duty, land tax if there's property involved? Where do you sit on stamp duty if you're moving companies around or doing a demerger? At what point is stamp duty due? Where are there reliefs? Where are there not? There's so many different layers. Income, the obvious one, particularly when thinking about employees and employment-related securities. How is that money going to be taxed?
And share options. That's probably the EMI options are probably one of the top of the list of what goes wrong in tax deals. The EMI option wasn't implemented quite correctly, and therefore it's no longer a capital gain that the employee was expecting. It's all income tax and NICs and things like that. So again, it comes back to managing expectations. And generally speaking, if you have a tax issue on completion, the quantum of the issue is the full proceeds, whatever. So if you've got your £10 million deal and the employee's getting £500,000, you can't really argue it's the value of the shares is any lower than that.
No, you can't.
Whereas if you've not got a deal on the table, then you bring in things like minority discounts, and it's $500,000 actually. Maybe it's only worth $100 million now.
Yeah, it's trying.
And so the tax issues are much lower by identifying that so early.
Yeah. I think the other issue we've seen a lot is buybacks, where people haven't executed a buyback of shares properly. They've just filed the return at Companies House and have done a buyback. When actually, no, you need an agreement for a buyback. You need to have it signed off by a resolution of the members. You have to pay for it in cash up front. You can't defer it. You can do tranches, but then obviously the shares are retained until the tranche is exercised, and that will be subject to reserves. It's got to come out of distributable reserves, and therefore fundamentally, from a tax perspective, you need clearance and how that will be treated. And
so the company buyback, actually, when it comes to company sales, I don't think the buyback is the tax issue isn't as great as the legal issue. So yes, when a company does a buyback, by default it's income tax unless you meet the strict capital conditions. And so we'll go to HMRC, get clearance that we meet the capital conditions, and the employee has had their shares bought back for them. That might not be an employee, but the shareholder has their shares bought back and they're out the picture. But if you identify this on the sale and you say, oh, you didn't have the reserves to do that, or you didn't do that in cash, therefore it's not a valid buyback, that person still owns the shares a lot of the time, legally.
So depending upon what the issue is, I think the worst one we had is someone that had no paperwork whatsoever. They just filed a return. Because there's this common misconception that what you see at Companies House is actually that once you've filed this thing, that's the position, like you just file an APO1. Actually, what you're doing is notifying Companies House of a change that's happened. It should mirror the legal position, but you need the actual legal paperwork. So if you don't have a buyback agreement, you don't have a resolution, if you just filed the return, arguably there's no buyback. Then, or if you didn't have the reserves, they might have to be paid back. The buyback could be void if you purported to do it on a deferred basis. If your buyback is void, there's no transaction. Suddenly, this shareholder that you did a buyback from 3 years ago is still a shareholder. Now that's where my question comes in on the tax, because actually if you were to do this buyback now and to execute it properly, where do we stand? What tax was paid at the time? Where do we sit with HMRC? You've got to look over, okay, well actually what happened then? Are we going to have to affect it legally now? But what if the company's more profitable? What if it's less profitable? Where do we sit? So you can get a lot of complications if a buyback hasn't been done.
The worst buyback for me was on an EOT. I think we were selling for about 8 million. I've told this story plenty of times, so apologies for people who have heard it before. I think we were selling on the EOT for 8 million. It was one shareholder at that point. So they were expecting to sell to an EOT, which means they would pay zero tax. But then when the lawyers did some due diligence, they found that this 50% shareholder from 10 years ago had a void buyback. They had been bought back for 200,000 £200,000. They'd done it. I mean, it was the legal advice was that this was void, and he still legally owns half the shares. You bought him back for 200,000. He now legally owns £4 million worth of shares. Is he actually going to be happy with you just rectifying something from 10 years ago? And is it going to have retrospective effect? Or is he going to go, hang on a second, if I still legally own the shares, I'll have my £4 million, please?
Yeah.
And it's those types of things that which is why I say sometimes the legal consequences can be a lot greater, because the company hopefully has grown in value since then. So,
but then I guess my flip question on that would be, if he was to sell for 200,000, so he was satisfied to still sell for 200,000, but the shares are actually worth 4 million.
4 million. Have we got to sell it under value? Have we got employment-related securities problems for the remaining shareholder? There's a whole host. We had Section 455 because we said, well, if you didn't actually buy the shares back, does that mean it was legally a loan to him at 200,000?
Yeah, what was that payment for?
And that's been 10 years, and because of Section 455 tax that says you should have paid 32.5%, then you've got all this interest on that you owe HMRC, and the interest itself was about 400,000. So
which is a lot. It's a lot of money.
So it's all of those things that if that had been a third party deal, it would have made it very, very difficult on the due diligence, because we'd have had to get that rectified whilst everything else was going on, and
which is another layer on deal fatigue. So not only are you doing a normal deal, trying to run your business, trying to do a normal deal, now you've also got to deal with the rectification of an issue, correspond with HMRC, get more information together. It's another thing you didn't have to do at that point in time.
Exactly.
It could have been sorted before. People often bulk at legal fees and lawyers. We have a reputation. I always say I'm trying to change the world's view of corporate lawyers one deal at a time. Yes, we charge. It's a professional service. But what's the cost of not getting it right in the first place?
I always try to say, look, we might not be the cheapest, but we try and add the most value. And I think it's exactly the same on the legal side. As you say, what's the cost of not undertaking this exercise and having it come up later? Generally speaking, it's going to be an awful lot more than any fees you pay to us to make sure everything's...
And it's not just the monetary cost, it's the peace of mind.
Yeah.
It's not having to go through the stress of having to deal with claims. Like, same as litigation, having to deal with the revenue. If you get a letter from the revenue drop on your door, I can't imagine that's a nice experience.
Yeah, exactly.
So, it's having the stress that it can cause and the knock-on effect that can have just in your personal life and relationships. Actually, what actually is it worth? It's probably more than just the monetary outlay.
Yeah.
I would also say it's normally a lot cheaper to get it done in the first place than it is to rectify the issue.
Yeah.
So you can pay us, or you can pay my litigation team 3 times the pound in a few years. Genuinely, it's one of those things. It swings and roundabouts, but do it right at the time. Plan and prepare. Prepare for sale is probably one of the key things.
There's so many, and I know we're completely out of time, but there's so many different things that you might do that you downplay at the time, either because the values aren't that high or something, but that's irrelevant if it remains an issue when the company's worth a lot more, which so I think all we can say is try and make sure you've got the best advice for everything you do through the transactions and through the history of the company. But we've run out of time. I
flew by. I
said at the start I had a script. And I had loads of things to talk through, but I haven't looked down at my laptop once, I don't think, other than to check how we were doing for time. So that's been a really enjoyable conversation. Thank you for joining me. Hopefully to everybody who's listening, it's been really interesting and useful. Don't forget to like and subscribe, and we'll see you on the next one. Thank you.
Thanks for having me.